Hello everyone, it's Jackie Jones and this is Module 3 in the lecture for Family Law, first week of lectures. This module is going to be talking about financial aspects of family law. Now that covers a number of topics, namely property adjustment between parties, spouse maintenance and also child support. Now, each of those topics could be a lecture in itself. So again, there's so much information and content in the family law. It's just a matter of trying to give you an understanding and an overall synopsis of the family law area. And those of you who have an interest in a particular aspect, there are plenty of resources online that you can make further reading on and expand your knowledge. So when I spoke in the first lecture, it was that property falls within Part 8 of the Family Law Act, and there are some critical sections that you need to know if you are dealing with property, and it will depend upon whether the parties are married or whether they are in a de facto relationship. The amendments in 2009 allowed parties in a de facto relationship to come to the family court. Of course, they need to satisfy the eligibility requirements. So again, if I was acting for a client in a family law matter that was looking at property adjustment between the parties and they were married, I would turn to Section 79 of the Family Law Act. If you were acting for a de facto couple, it would be Section 90, capital S, capital M. And those sections really look at broad aspects of what the court is to consider when determining a property adjustment between the parties. We often talk about contributions, and they are in a number of ways. So it can be a financial contribution, either directly or indirectly, to the acquisition, conservation, or improvement of property by, and importantly, or on behalf of parties to the marriage or relationship. Or it could be a non-financial contribution to the acquisition, conservation, improvement of the property by the parties or on behalf of the parties to the marriage and the relationship. So you've got very broad ranging contributions. And then you also have the contribution in the capacity of homemaker and parent. So there was a case involving Hickey in 2003, and that set out a four-step process that most lawyers nowadays still adhere to. It's been slightly altered because of the High Court's decision in Stanford, and then that was reconsidered in Bevan. But the first approach is really to identify and value the property of the parties. So construct a balance sheet, so to speak, and often it's easier said than done. But there's a lot of time and effort that goes into constructing a balance sheet, and when that has been achieved, assessing the contributions that the parties have made themselves or that have been made on their behalf, and then looking a little bit into the future needs and resources of the parties. And if they're a married couple, 75(2) is your critical section, and if it's a de facto relationship, Section 90, capital S, capital F for Fred, is the relevant one there. On slide 5, I've just done a quick comparison of the relevant sections for you that you might find very useful. So section 77 is a very important section, as is section 79A. Section 79 setting aside an order. Section 90B, C, D and G relate to binding financial agreements, and you'll see the appropriate sections for de facto couples. So that might be a handy reckoner for just to keep. The court can approach property adjustment between the parties either looking at it on an asset by asset basis or globally. And my experience is asset by asset is usually only used by the courts and parties in negotiation if it's a relatively brief relationship or marriage, and really it's very clearly defined what they brought in and how the contributions, financially or non-financially, were made to the specific assets. Certainly my experience is that the global approach is much more the appropriate and well used one in the court system, and negotiating externally of the court system through the legal advisors. There's no point of equality as a starting reference for contributions, and it really is one of digging deep into the instructions of the parties. In a negotiation that I'm currently involved in, a particular aspect of concern for my client is his parents' non-financial and financial contribution directly to property that is in his name in New Zealand. Now, that the pieces of real estate are managed by the parents. The parents have appropriate skills to do that, so the parties have saved on rental managers, real estate managers doing the management of those properties. The parents have also been engaged in the renovation. The mother again has a skill in that area that they would otherwise have had to have engaged a person to assist with redecorating and renovating to maintain the property's value. And so it has been a subject of some discussion in the negotiation as to what weight will be given to the contributions by my client's parents. It is not a mathematical calculation. He finds that a difficult concept, but if it went through the court system, the court would not go through it on a dollar for dollar basis, but rather look at the evidence of the parents and the respective parties, and maybe the evidence of experts as to what was actually contributed by the parents to that property. After negotiating for some time on that, the wife accepted and conceded that the parents had in fact saved the parties significant money and had been instrumental in their contributions to a number of pieces of real estate that the husband owned, and there was an allowance that was made for that. So when you're talking about financial adjustment, there is that component of property between the parties. What is an asset? What is it that the parties have that they have to divide? And full and frank disclosure is incredibly important in any financial matter before the family court. Don't ever underestimate the need for parties to make a full and frank disclosure, providing all their documentation. There is a requirement under the family law schedule and the rules for there to be a disclosure by way of providing documentation to the other party, tax returns, superannuation documents, and any other relevant information that may assist the party to engage in meaningful discussions. So that's a pre-action procedure to assist the parties in dispute resolution prior to court process being commenced. The Federal Circuit Court has an expectation that that will occur in financial matters that are before that court as well. And it is not uncommon that there will be one party that usually has a greater knowledge and understanding of the party's finances than the other. Sometimes it is as a result of coercive or controlling behaviour. Otherwise, it's merely an election that one person is just not terribly interested and one is in financial matters. And so what is important is that both parties have a knowledge on the same basis so that they can make an agreement based on information available to them. And so this is where some tension is created in that balance sheet. So I've just created a balance sheet in another collaborative matter recently, where I was for the husband. The wife was quite concerned that she didn't have knowledge of the financial matters of his salary and his income and his entitlements, and my client readily made available to her and her accountant all the information that was needed or requested to satisfy her as to what his income was, what his benefits or entitlements were. She had access to their share portfolio and bank accounts, but there was his income that was of a concern to her. After we were able to identify all of those issues and take that concern away from her, the actual creation of a balance sheet became quite an easy scenario. But some people will fight over everything. The value of a car, for example, the value of furniture and contents, what's a painting worth, jewellery. I've certainly been involved in a number of cases where jewellery is an issue. Just remember that chattel value is not an insurance value. Clients will say, oh, well, that piece of jewellery might have cost X $1,000, or we've got furniture and household contents insured for X thousands or tens of thousands of dollars. The value will be attributed by an expert if required, and it will be the resale value, the current value as at market, not the insurance value. So that's an important point to be aware of as well. And of course, as part of assessing how the pool is to be divided, so to speak, it's looking at the contribution. So you can get a snapshot of getting a financial picture by way of the balance sheet, determining what money is available to distribute. And then the question is, well, how is that going to be distributed? And that's where, for example, married parties, section 79.4 is the critical key with looking at those contributions, including the contribution of homemaker and parent. And importantly, under section 79.4, it springboards you into section 75.2 factors, which lawyers like to call the future needs and resources. Section 75.2 is also an important component for spouse maintenance. Now, this is money that one party requires to assist their own maintenance, not that of a child. Spouse maintenance is linked under Section 72 of the Family Law Act, and there is a right to that. It's linked from a time point of view to a divorce order, and you only have 12 months from the date a divorce order becomes absolute to either reach an agreement on a spouse maintenance matter, or you'd need leave of the court to file an application. Most spouse maintenance are interim matters, but there are regularly urgent applications filed, and they are under section 77 of the Act, and usually it is a stopgap matter if it's an urgent order until the matter comes back before the court on the next occasion. What's important about spouse maintenance or interim matters, including the interim application you're going to do for your assessment, is that in the family court these are done on the papers, and that means that it is rare for the deponent of the affidavit to get into the witness box and to be subject to cross-examination. So that's a real flashing light for you as to the need why the documents are to be clear and to be concise, and to have the evidence to support the orders that you are asking the court to make. In a spouse maintenance, there is a threshold test. One is, does one party have a need? My experience is that's not a difficult one to prove. The second limb, which is usually the one that's more challenging, is, does the one have a capacity to pay? Slide 10 talks about spouse maintenance in a little bit more detail. Again, I can't stress enough how important a financial statement is to be completed clearly, concisely, and with as much detail as you possibly can. You need to really press the client to make sure that the financial position as disclosed in that financial statement is true and correct, because that's the document that, if it goes to trial, will be the subject of scrutiny by the barrister on the other side and cross-examination. And importantly, if there is an interim matter of a financial nature before the court, that financial statement will be referred to in submissions. Now, on slide 11, I've just again given just a cross-reference for the section of the Act that relates to de facto maintenance, just for easy reference for you. Child support is again an area of family law that could be a whole lecture on itself. It is it's a scheme that came in that produced what's called an administrative assessment. It's formula based and it is currently under the umbrella of the Department of Human Services. I don't have the time to spend in detail with it, other than the parties do agree and can enter into a child support agreement, and there are two types of agreements as stated on slide 12. Maintenance is for a child under the age of 18 years. You can have maintenance for a child over the age of 18 years, but that's under the Family Law Act, not under the child support legislation. And in fact, it's a negative that there will not be child maintenance paid for a child over the age of 18 years unless falls within one of the parameters. Slides 13 and 14 just talk a little bit further about child support. What usually will happen when a client comes to see you and there are children, what you need to explore is whether they have whether there has been an application lodged with the Child Support Agency for an administrative assessment to be made, namely the application of the statutory formula, which is based on the income tax returns of the parties. That formula takes into account, for example, the number of nights that the children stay with their parents. Or alternatively, whether the parties do have some other arrangement on a voluntary basis where they've agreed to how the child support will be paid. And that's not uncommon, particularly if one parent might be paying private health insurance or private school fees, or some other costs that may not be the weekly periodic amount. You just need to have a bit of a flashing light if the parent who has the primary care of the children is receiving a benefit from the government. You just need to be mindful of that as to what their situation is with agreeing to funds and entering into child support agreements. Dispute resolution is a real option in family matters, both prior to the commencement of any court process and within the court process itself. And in fact, Workshop 1 has been designed to get you looking at and thinking about what are the requirements for parties to engage in dispute resolution prior to commencing any court process, or once the court process has in fact been commenced, and that there are obligations in both the property or financial aspects as well as parenting. There are a number of options that parties are engaged in with ADR. It's very common for there to be without prejudice meetings that are conducted by lawyers. The court is regularly referring matters to mediation. The Law Society has a mediation scheme for family law matters. The courts are terribly blocked and the time delays are enormous, so there's a lot of referring to mediation. Another dispute resolution process is collaborative practice. This can be an interdisciplinary model where a team of lawyers and social scientists or mental health professionals assist the parties to reach an outcome using interest-based negotiation principles. It's a commitment of parties not to go to court. There is provision for arbitration and the Family Law Act, but to my knowledge it's not being used. But certainly negotiation is an effective tool to resolve issues. And of course, if you've been able to resolve issues, then that's finalised in a number of ways. Either a consent order, which is submitted to court for approval, and I'll talk about that in Lecture 2, or you could even have a financial agreement, you might refer to as binding financial agreement, which identifies the negotiated outcome. Of course, if there isn't an outcome that the parties have negotiated, a court will determine the orders and determine the matter as between the parties and deliver a judgment. there's always the right of an appeal from a judicial determination, and that's much more frequent than an appeal arising from an agreement reached between the parties. As I tell my clients, a negotiated outcome is the only outcome really where there's certainty. And that's the end of this module for lecture 1. Thank you.